or substantially, or not substantially more detrimental to the neighborhood. And then the protection can be lost if there's a significant change in the nature or purpose, quality or character or use, or the altered use imposes an impact different in kind on the neighborhood. So that's called the powers test. And there's a test that you go through. So if somebody comes in and they have a non-conforming industrial use in a residential neighborhood, and they want to change that use to a commercial use, there's a whole list. We have to do the powers test, and we have to decide, is there a nexus between the current use and the proposed use? If there is, you move to the next step, which is, will there be an impact on the neighborhood as compared to, you know, the existing use and the proposed use? And so there's all kinds of steps that we can take. Generally, generally the case law is that it's very hard to change a non-conforming use. So with my example, from an industrial use to a commercial use, or let's go opposite, a commercial use, say, like a mini mart, to an industrial use, which would be where they're going to manufacture something and also sell it. So it's still a retail use, but they've brought in this manufacturing, and there's going to be a lot of trucks and noise, and so it's not easy to change. It's a finite test that you guys go through that you have to determine.
I have lots of questions probably, but who decides what constitutes intensification?
You guys.
We decide
Yes.
that.
Yeah, you decide that. So,
Okay.
for example, going from, you have a two-family in a single-family single-family zone, you have a two-family house, and they want to increase that to an 8-unit building. So is that intensification more detrimental to the neighborhood?
Okay.
And that's what you guys have to determine. So, and the one thing with zoning, and the decisions that you guys make is there's essentially no precedence for your decisions, because every single application that comes before you stands on its own, because you can never have two pieces of land that are exactly the same. So you have to look at each application with fresh eyes. Non-conforming structures. These are structures that lawfully exist prior to the adoption or amendment of a zoning bylaw, and they can continue. Reconstruction, extension, or structural change or alteration requires a special permit of finding that the change is not substantially more detrimental to the neighborhood. So that means if you have a house that is in the side setback, say the side setback is 20 feet and they're 15 feet from the side setback line. They'll come in for, say, a second story, or they'll come in to, do an addition to the back. So they're going to intensify or extend that nonconformity. And is that more detrimental? Now, if the creation of a new nonconformity requires a variance. So if you have a house that has a side that's nonconforming because of the side setback line, and then they come in and they want to add 4 stories, so the height is going to be increased and going to be non-conforming. That needs a variance. So any new non-conformity needs a variance. So with in the prior slides or pages, I was saying you either need a special permit with a finding. If you have a non-conforming single or two-family residential dwelling, 40A Section 6 allows for the alteration, reconstruction, extension, or structural change if it does not increase the non-conforming nature of said structure. So, going back to our example with the house that's 15 feet, the non-conformity is the side setback. If they want to add a porch onto the front and they're not going to encroach that front setback line, they can do that, because they're not touching the existing nonconformity. They can add an addition, provided that addition is not going to create a new nonconformity or extend the nonconformity they have. And then any expansion, alteration, or intensification that increases an existing nonconformity, that requires a special permit and finding that the change is not substantially more detrimental to the neighborhood. Under your zoning bylaw, it's very, not very clear as to whether the finding is a finding or a special permit. So in those instances, the courts have held that you follow the special permit standards. And so
Do you think we should clean that up?
yes, very much so.
Is that something you could
I
maybe
could
propose
suggest, yeah, a
and
whole
put
new
a draft
section.
together and
Whole new section, because,
that might be helpful to
Yeah.
us?
yeah, it would
In the
be a lot,
future.
it would make your jobs a lot easier.
Yeah.
Yeah,
Okay,
because it's, right now, it's horrible.
okay,
And
thanks.
you're not the only ones at all. Because we had a case in 2012, and then I think we had a case in 2018 that kind of firmed all of this up. The SJC, firmed all of this up. So all of the bylaws that haven't been changed since then are kind of out of whack, so.
Okay.
So for non-conforming single and two-family residential dwellings, there's a two-part inquiry for the building commissioner or the ZBA. In your instance, it's the ZBA. Identify the particular respects with which the existing structure does not conform, determine whether the proposed alteration or addition would intensify the existing nonconformity or result in new ones. So if there's a non-conforming structure that's going to have an addition that's conforming, that stays downstairs with the building commissioner. It's only when it comes to you guys that you guys have to determine if it would intensify the existing or result in new ones. If the project does not intensify or create new ones, the applicant is entitled to the issuance of a building permit. But if it will, then the ZBA, you guys have to make a finding whether the proposed change, extension, or alteration will be substantially more detrimental to the neighborhood. So you guys, under 175-68, you have a provision that says the provisions of this article apply to non-conforming uses, structures, and lots as created by the initial enactment of this bylaw or by any subsequent amendments. So that means that if you have a non-conforming house, or you have a house on a 20,000 square foot lot, and the zoning changes, and that they make the lot requirement 40,000 square feet, that's a grandfathered lot. So they're legally non-conforming. They're legally pre-existing non-conforming is the official term. So while there's no zoning violation or anything against them, if they decide to do anything to that house, they then have to go through this whole scenario. Is it going to be more non-conforming? Are you going to intensify the non-conformity? Are you going to create a new non-conformity? So that is the one downfall of that, I guess. And then we have exempt uses, which is 48 Section 3, which is the Dover Amendment. And it is, you cannot prohibit, restrict, or unreasonably regulate certain uses. Those are commercial agricultural uses, religious purposes, education purposes, and childcare facilities. No zoning bylaw shall prohibit, regulate, or restrict the use of land or structures for religious purposes or for educational purposes. With childcare facilities, you can require site plan review. Municipalities may not deny a use that's subject to the Dover exemption, and special permits cannot be required for Dover protected uses. So to determine whether the use is a Dover use, you have to determine whether the uses and structures have a bona fide goal that can be reasonably described as educationally significant or religiously significant. And that goal must be a primary purpose for which the land or structures will be used. So one of the most famous Dover cases is the Regis College case, which is where Regis College wanted to build a dormitory, but the dormitory was going to be assisted living. And they were claiming that because they are an educational use and that they are building a dormitory, then they can just do it. And we argued, no, it's an assisted living facility. It has nothing to do with education. And so that case, they lost. The town, we won. The town of Weston. And then there's a more recent one, which is the McLean Hospital case, which was they were building a facility for troubled youths. And we argued that has, there was no educational component to that. They countered by saying that the educational component was life skills. They were teaching these troubled teens life skills, et cetera, and they won. We lost on that one. So I'm not trying to make you think that I'm perfect, because I don't always win,
Right.
okay? So, I'm not perfect.
I know.
So, I like to give the good and the bad, but I still think we should have won that case, but anyway. So that's how they decide, uses. Usually with educational, if somebody's putting up a school, great. Religious, it's a little more difficult because, anyone can create something, so you have to get into the creation of this religion and all that stuff, but anyway. The Dover uses, such land or structures may be subject to reasonable regulation. So that means that if you're going to build this dormitory, we can still look at the bulk and height of the structures, the parking, yard sizes, lot area setbacks, open space, and building coverage requirements. So that means that even if they are protected under the Dover Amendment, they can't put a building on every single inch of the lot. There has to be, reasonable regulations. And, so they have to do reasonable parking accommodations. They have to do reasonable screening, setbacks, building coverage requirements, things like that.
And who puts those regulations on? Is that,
Usually it's the building commissioner
Okay.
will determine whether he thinks that they're, reasonable regulations. But that determination, the building commissioner's determination will be challenged, and that appeal will come to you. So, the applicant may challenge the local as unreasonable as applied to its proposed project, and further demonstrate compliance would substantially diminish or detract from the usefulness of a proposed structure or impair the character of the land structure without appreciably advancing the municipality's legitimate concerns. That is the Mormon Church case, which was on Route 2. If you're heading Route 2 into Boston, there's this enormous, I guess it's a steeple, but it's not called a steeple. And so the town of Lexington tried to limit the height. And the Mormon Church came back and they had all of these reasons for why it had to be as high as it was. And they won. So now we're getting into timelines for, for all of these permits, which generally Nancy handles and does a great job at that, so you don't necessarily have to worry too much about this. But for a special permit, the application is filed with the town clerk. A hearing has to be opened within 65 days. Once the hearing is closed, you have to have a decision within 90 days, and that decision is filed with the town clerk within 14 days. I recommend always having the decision filed within that 90 days, and then there's no argument. With a variance, a variance is a little bit different. So you don't have the 90 days afterwards. You have 100 days total for a variance. So for variance, an application is filed with the town clerk. The hearing has to be opened within 65 days. The hearing must be closed within 100 days of the filing of the application with the town clerk. You then have 14 days after that. There is case law that says that you have 114 days. Again, I suggest not pushing it. The other thing about special permits and variances is that the 65 days, the hearing must be open within 65 days. There's numerous cases that have said that that is not fatal. So that is directory, not mandatory, because there is no constructive approval attached to that 65 days. There is constructive approval attached to the 90 days for special permit and the 100 days for variance.
so if you don't issue your decision within that period of time?
It's
deemed
constructively approved,
approved.
as stated on the application. And I don't really know of any of any zoning board that takes 90 days to issue a decision after you close the hearing. It's very rare. With a comprehensive permit, which is a 40B, every single deadline is important and means something. So there is no leeway. The application's filed with the town clerk. The hearing has to open within 30 days. It has to close within 180 days after opening, and a decision has to be filed with the town clerk within 40 days. We've gone through a few 40Bs here, and we almost always get extensions. The 180 days is never enough time, so we almost always get extensions. And if you get an extension, that's fine.
So if the proponent agrees to extend, then you can go beyond.
So it has to be in writing, signed by the applicant, and filed with Nancy and the town clerk. So for the quantum of vote on these, all of these things that you guys have to do. So you're a 3-person board, and so a special permit requires a supermajority, but a 3-person board, that supermajority is unanimous. If you are a 5-person board, the supermajority would be 4 out of 5. If you were a 7-person board, the supermajority would be 5 out of 7. But you guys, everything's 3 out of 3. So special permit, variance, and an appeal are all 3 out of 3. A Section 6 finding is going to be a majority because your zoning bylaw does not address Section 6 findings. So you are, you're really issuing Section 6 findings under the Act, under the Zoning Act. So you could have a bylaw that says that the finding will be a special permit issued by the ZBA. And if that's the case, it's a 3-3. It's a 3-3. It's 3 out of 3. But because you guys don't have that, yours is a majority. And a comprehensive permit is a majority. So if you guys have a motion to approve an application and it fails to achieve the necessary votes for approval, the motion fails and the project is denied. You do not have to do a housekeeping motion to state that there is a denial. You can choose to do that, but you don't have to. So if 2 of you vote yes and 1 votes no, it's denied. And you can just leave it at that. So when you review an application, you want to review the nature of the proposed project, whether it's residential, commercial, industrial. You always want to know, what is the relief sought? Is it a special permit? Is it a variance? You always need to have the current zoning bylaw and zoning map available. The zoning bylaw generally changes once a year. There's, I would say, every year, if not twice a year, there are zoning amendments in Abington. So you always want to have the most recent zoning bylaw. You want to determine what zoning district the property's in. You want to review the plan for existing conditions and existing nonconformities. You want to note the required dimensional, or use controls, meaning, if this property, if they're looking for access, but they're not putting their access through the frontage, in Abington, that's not allowed. In Abington, under Section 14, you have to put your access through your frontage. So you can't come in the back, you have to go in the front. And you have to determine if any existing nonconformities will be increased. So nonconformities are structures within the setback, structures too high, exceeding lot coverage, an undersized lot, which you're gonna see, I think it's very common. A use that's no longer allowed, meaning, an industrial use used to be allowed in a certain zone and now it's not. And any situation which is not in accordance with the bylaw. So to issue a defendable decision, you want to, in your motion, you want to do the identity of the applicant or the property owner, full address, the jurisdictional basis, meaning special permit, variance, findings of fact, which is required under the applicable statute or bylaw. So if it's a variance, you have to determine if there is an unusual shape or topography, if there's a hardship, and if it would derogate from the intent of the bylaw. And then any other determinations or reasons for the decision. And then in your decision, not necessarily in the motion, you always want to put any relief not expressly granted hereunder is hereby denied. So for special permits, those come under Chapter 48, Section 9, And zoning bylaws provide for specific types of uses which shall only be permitted in specific districts upon the issuance of a special permit. Special permits may be issued only for uses which are in harmony with the general purpose and intent of the ordinance or bylaw. So you could have a provision that allows for multifamily in a single-family district. But if somebody comes in with a large multifamily development, is that the appropriate place for that? And because it's a special permit, it's discretionary, which means you guys can make that decision, whether it's appropriate or not. Special permits allow for the use or dimensional requirements to be imposed under a discretionary authority, and you evaluate whether the purpose is in harmony with the purpose and intent of the bylaw. Special permits can be conditioned, which allows for greater creativity or flexibility in permitting certain uses. So you could allow if they have special permits for a small retail in a residential district, you could allow for that store to go in, provided the hours they close at whatever time and nothing's lit up after a certain time, things like that. Applicants are not entitled to a special permit. They are discretionary. Local bylaws have to provide adequate standards for guidance of the special permit granting authority to grant or withhold special permits. Your bylaw does do that. It goes through a list. Special permit decisions are limited to the criteria detailed in the bylaw. They require a supermajority, which is 3-3. You cannot refuse to issue a permit for reasons unrelated to the standards of the bylaw. So you can't say no to a project unless it's within the zoning bylaw requirements for a special permit. And you can't base your decision on the reputation or the character of an applicant. That's really doesn't need to be said. So when you're reciting the legal requirements when you're reciting findings, you don't want to say, you don't want to have a finding that says the project would not be substantially more detrimental. You want to say the project would not be substantially more detrimental because it would add 500 square feet to an existing single-family dwelling that is lawfully non-conforming and would not create an additional impacts on the neighborhood with respect to traffic or interference with light and air, would conform visually to the size of the majority of the dwellings that already exist in the neighborhood. So that kind of follows your bylaw. And the special granting authority, you have to give reasons for denials. If you guys issue a denial, you have to say why it does not fit in. The Zoning Act specifically authorizes you guys to impose conditions, safeguards, and limitations on the time or use of the issuance of a special permit. So examples are deadlines to commence construction, limitations on vehicles, noise, landscaping, hours of operation, a time limitation on permits and renewals. Those are really only come into play on in-law apartments. A special permit, unlike a variance, may be conditioned by limiting its duration to the term of ownership or use by the applicant. Again, that's mostly for in-law apartments. And then special permits have to be exercised within 2 years, and that's pursuant to your bylaw. The Act 40A, one of the changes in 2016 was that the Act said that you can grant, that special permits can have they'll lapse after 1 or 2 years. The town decides whether it's 1 or 2. And then in 2016, they added 3. So it can now be 1, 2, or 3. So the decisions of, you have plan conditions. So when a special permit is accompanied by plans or specifications detailing the work, the plans and specifications become part of the conditions, the issuance of the permit. So the plan is referenced in the decision. Submitted plans and specifications should be referenced and filed with the decision. That's almost always done. Delegation of authority. Conditions that attempt to delegate or defer decisions have been rejected. So therefore, you cannot, in your decision, you cannot say that if the applicant submits XYZ and the building commissioner is satisfied with that, they get their special permit. They either get their special permit or they don't get their special permit. So you can grant a special permit and require that they come back in a year to show that their landscaping has taken, or, you know, that the plants have grown or something like that. But you can't delegate the authority to grant a special permit to somebody else. And that really only ever comes up in 40Bs when we have these large developments, that it's really an issue. With variances, that's Chapter 48, Section 10. Variances are from the terms of the local ordinance or bylaw. They're primarily dimensional, however, you guys allow use variances in your zoning bylaw. So normally variances are, you know, I need to build an addition and I'm gonna go into my setback. You need a variance for that. But here a variance would be, I wanna put a two-family house in a single-family residential district. The use is the variance. And the use variances are only allowed if your bylaw specifically authorizes it, meaning it says zoning board of appeals may grant use variances, and yours does. So the required findings for granting a variance, soil, shape, or topography. So you have to make a finding that the land contains unique circumstances related to soil conditions, shape, or topography of the land or structure, which especially affects such land or structure, but not generally affecting the zoning district in which it's located. So if you have if somebody comes in and says, it's my number one finding is shape, because my lot is so tiny, but every lot in that area is tiny, that doesn't fly. Or if they say, my hardship is wetlands, I have numerous wetlands on my property, but the entire neighborhood is wet, that won't fly. With topography, a lot of times you could have a property that has a ton of ledge, and so they have to locate their house somewhere different because of the ledge. If the entire zoning district, you know, the entire area around them or zoning district does not have this ledge problem, that would work. And then you also get these crazy shaped lots, because, you know, at one time there was no zoning. So you have these weird, like, long, thin lots, where the other, you know, every other lot in the neighborhood is perfectly square. And that could possibly, you know, classify for shape. You have to have a hardship. So the literal enforcement of the provisions of the ordinance or bylaw would involve substantial hardship, financial or otherwise, on the applicant. However, the applicant cannot create their own hardship. So the applicant cannot subdivide their property into two lots and make one lot a crazy weird shape and build on this property and then come in and say, I need a variance to build on this because of the shape. They created that. So there's numerous case law on that. They cannot do it. And then it has to be, you know, public good, that desirable relief may be granted without substantial detriment to the public good, without nullifying or substantially derogating from the intent and purpose of the ordinance or bylaw. That really comes into play when you have, if somebody is looking to, they're looking for a variance from a setback, but they're staying as far away from that lot line as they possibly can. They're not right on the lot line. So they're not, you know, they're not coming in with a building that, you know, goes from lot line to lot line and covers the entire lot. They're doing the best they can is kind of how I see that. So if a variance is granted, it authorizes dimensional requirements that would otherwise be prohibited. You can only grant them if they satisfy the statutory requirements. The burden is on the applicant to prove all three of the statutory criteria. Hardship alone is not enough. The applicant is not entitled to a variance. Decisions are easily appealed if statutory criteria is not met. So variances are very, very hard to get, and pursuant to Massachusetts case law, variances are not allowed as a matter of right, but rather should be sparingly granted, is the term that the courts have used. Extensions and lapses, variances may be extended up to 6 months. It lapses if it's not exercised within a year of the date granted. Exercised is more than just recording it at the Registry of Deeds. There has to be some kind of action in reliance upon the variance. So you have to, when there's a question, it comes before you, has this lapsed or not? You know, you have to figure out if they've substantially exercised their rights. So did they pull a foundation permit? Did they put in put in a curb cut, something? There has to be more than just recording it at the registry. The permit, you guys can impose conditions, safeguards, and limitations of time and use, including the continued existence of a structure, but you cannot base any condition of a variance on ownership. So a variance, without a doubt, runs with the land. So
Once you grant the variance, it's there for
it's there forever.
forever.
Yep, it's good forever.
Now, if someone buys a piece of property that they need a variance at, is that, can they consider that a hardship?
If they can do it if they can prove that there's, soil, shape, or topography, because they didn't necessarily create it.
That they're buying something
yeah.
that needs a variance?
Right. But they're not creating the variance. So.
Buying it too, though, I mean,
Yeah.
a property that needs
Yeah.
a variance.
And variances are not given out, they're given out sparingly, so, they might want to think about that purchase.
Yeah.
So accommodations for persons with disabilities, under 48, Section 3, that provides that local land use, health and safety laws, regulations, practices, ordinance, bylaws, and decisions of a city or town shall not discriminate against a disabled person. There are limited Massachusetts cases that address this. Under the Federal Fair Housing Amendment of 1988, it's unlawful to discriminate against a person with handicap by refusing to make reasonable accommodations in rules, policies, practices, services, when such accommodations may be necessary to afford such person equal opportunity to use and enjoy a dwelling. There are many cases out there that says that that recovery houses are, that is a disability under the Federal Fair Housing Act. So when reviewing an application for zoning relief, the board may consider whether the accommodation request is reasonable and necessary to provide the applicant an equal opportunity to enjoy their house. So that equal opportunity, the courts have determined that that is giving handicapped individuals the right to choose to live in single-family neighborhoods. And necessary means, but for that accommodation, they will likely be denied an equal opportunity to enjoy housing of their choice. And so that goes to, for example, group homes where someone takes a single-family house and puts in, 6 bedrooms. And they can do that, provided that it's some kind of group home or something. The other thing is that handicap ramps are, they can be in the setbacks. They're exempt from the setbacks. Where state law provides for public health and safety concerns, 43 will not exempt an applicant from complying with such state laws, and that's the requirement to provide sprinklers in a group home or a lodging home. And that was a huge case out of Springfield. It was not my case. I didn't win that one, but somebody else did. The open meeting law. So meetings must be posted 48 hours ahead of time. You guys have to, they have to be posted with the town clerk and on the website. A quorum of members cannot deliberate unless you are in an open meeting, and a quorum is the majority of members in office. So you guys, it's very, very tough for a 3-person board, because if 2 of you talk, you're a quorum. So, so for public meetings, the public has to have the same access to the meeting as the board. So this was an issue with virtual hearings where there would be an instance where the board would be on Zoom, but the public couldn't get on, or something like that. Then you have to shut the meeting we're not gonna run into that much anymore, hopefully.
Hopefully.
Hopefully. You cannot deliberate via email, which means never hit reply all. Just don't ever hit reply all. Just if Nancy sends out an email asking a question about anything, just answer to Nancy. You can do scheduling via email. So recently Nancy sent out the email about packets and picking them up. That's fine. But it's always just safe not to hit reply all. You can distribute materials via email, but those materials also have to be available to the public. So Nancy can send out your packets, and then somebody comes in and asks for that. They are entitled to get that. That is a public record. I have a double slide. I don't know if you guys do too. Sorry about that.
Yeah.
Andy, you didn't pick up on that.
No, I did not.
Oh, Andy.
Site visits. On-site inspections are not a meeting that must be posted, provided that members do not deliberate. If you do post the meeting, a site visit, you have to remember to state the board cannot invite members of the public onto private property. So when you're dealing with a site visit, it's usually best just to do it on your own, or if you go as a group, just don't talk to each other. Say hello, that's it. Conflict of interest, municipal employees have to receive a summary of the law. You are municipal employees. You must complete online training, and you cannot act on a application if you have a financial interest. You can't act if you're related to the applicant. You cannot act if you're in a butter or a close resident, because that goes to the financial interest. And you can't act if you have bias. So if you really don't like somebody a lot, just don't act. But that never happens. Public records. So what are public records? They are records made or received by a governmental body, official, or employee. They're public records unless they are an exception, and that exception is essentially if they come from me. So if they come from me, they are attorney-client privilege. Emails are public records unless there's an exemption, which is, again, from me. Public records may also include text, social media posts, and other electronic communications, even if it's sent from a personal email account. File documents are public records unless, of course, there's an exception. That's more along the lines of police reports, anything that has somebody's social security number or things like that. Minutes are public records unless there's an exception, and the exception there is the executive session minutes, which are not approved until the subject of the executive session is completely over. So that means if we're gonna go into executive session about litigation, once that litigation is absolutely 100% concluded, the chair then goes into those minutes and decides if they can be released or not.
What if you sent out like an advisory letter to us? Is that public record? Saying, I think, it's an opinion letter or something to the board.
So, no, that is not a public record until it's discussed in an open meeting.
So if we started discussing your opinion letter, then it becomes
Yes.
public record?
Yep. If it's, if I issue a memo to the board and I come to the meeting and I bring it, that's a public record.
Okay. What if you don't come to the meeting, but we
If
discuss
you
it?
discuss it,
then
it's a public record. So, the attorney-client privilege lies with you, not me. So you decide whether it can be released or not. Minutes, have to have the date, place, and time of the meeting, the members present and absent, the topics discussed, and motions and votes. It doesn't have to have, you don't have to have a transcript of the meeting at all. So that's it.
Explain that last thing you were saying. Andy was saying that if you put something out in writing to us,
Yeah,
we don't have to mention it?
no. No. But if you do, it becomes public record.
So that attorney be able to, because we've had that problem before.
That's why, that's why.
Yeah,
I
we've had
asked.
that problem
Yeah.
before.
But if we discuss it and they want to see it, then we have to let them
Yeah.
see it at that point.
Yeah. So it's only once it's discussed in an open meeting.
All right.
I want to try to understand better the idea of going from a non-conforming something to a conforming something that's a different use.
So that's completely allowed.
Okay,
So you're going from, if you have a non-conforming use and you change it to a conforming use, you can do that.
right, but like a conforming use, but of a different type, like from residential to commercial or residential to industrial, what, it seems like if you make that change, is there requirements imposed upon the new use?
Under your zoning bylaw, there is. So under
Okay.
your zoning bylaw, if you change if there's a change in use, you have to go through site plan approval with the planning board.
It requires public notice and all that
Yeah.
other stuff? Okay.
Yeah, and that is not, so site plan review is not a creation of 40A. It's a local control. So it's only in your bylaw, it's not under 40A. And so no town has the exact same site plan review. It's all different. So some towns have it where site plan review is only required for commercial, industrial, and if you're adding, 2,500 square feet or more, or, 10 parking spaces or more, that's the trigger for site plan. Yours is more broad. The trigger, one of your triggers is if you change uses, you have to go through site plan.
Even if they're both allowed uses, you still have to.
Yeah,
Just to change the use itself
Yeah.
triggers that.
yeah. And site plan review is if the use is allowed in the zoning district, it's non-discretionary, meaning they can't deny site plan review, but they can condition it.
Another thing I'm curious about, since I'm curious about other things, is that the transition zones between different types of uses seems to be a potential trouble area, like from residential to commercial or residential to industrial. Is there any case law that can help us understand what to do in those circumstances when people are at odds over what has happened?
No, because the zoning district lines are the zoning district lines.
Okay.
And so, now, you guys have a provision in your zoning bylaw with regard to split lots. If you have a lot that's half in one district and half in the other, I think your zoning bylaw says it has 50 feet. If it's 50 feet in, it's the less, it's like the less intense use or something.
Okay.
If you have a use that the access has to go through, so, in the Beal case, which was, it was in Rockland, they had an industrial zone, and they had an industrial use, but to get to that industrial use, they had to go through a residential neighborhood, and they were held they can't have that use. So the access has to be the same zoning as the use.
Are you going to be around during some of our later deliberations, or do you have
Yes.
to? Okay,
We always ask for Amy.
thank you.
We always ask.
Yeah, she'll be here the whole evening, so.
We always, Nancy, could you get Amy, please? And that is why she's at our meetings.
I don't mind your meetings.
Any other questions, guys?
I was in Essex last night. Got home at midnight.
Oh, you're gonna be here for the whole thing of this, right?
Yeah, but I'm only 20 minutes away.
That's awesome.
It's not like I'm an hour away.
That's right.
That was very good.
Thank you.
Thank you very much.
Very informative. So now we'll wait 5 minutes till 7 o'clock because the first petition's at 7 o'clock, so we can take a break for 5
Do you
minutes.
want, or we could do our executive session, which will take 5 minutes.
Oh, all right.
Oh, really?
Yeah,
Okay,
do you want to do that?
that'd be fine if
Okay.
that's gonna move things along, yeah.
Is that,
Yeah,
Everyone
so,
else?
yeah, they just, oh, hey, I didn't know you were here.
So,
I got your message, but I haven't looked into it, I will. Thank you. Yeah, I'll do that tomorrow morning.
we're gonna do the,
Yeah. Yeah. Yeah.
I'm Jim Van, building inspector.
oh.
how you doing?
Nice to see you, thank you.
Something, Amy's the go-to person.
No, Jim knows some stuff too.
Thank you for coming.
If you've got a question, just get a hold of us. I'm out of the office usually between 10 and 2 doing inspections. But other than that, you can always call, leave a message, leave a number, I'll get back to you.
Nice to meet you.
Great,
Thanks.
thank you. Thank you.
Bye, Jim.
Thank you.
So I'm gonna ask you, hey, Ron, how are you? I'm gonna ask you guys to step out, because we're gonna go into executive session for a brief period. And,
And would you guys mind shutting those doors?
we need to have a motion, though, right?
Oh, yeah, have the motion and open.
Don't shut the doors till we do the
Yeah,
motion.
you're right.
I
So-
move that we go into executive
For the
session.
purposes of litigation,
Litigation, where the chair has determined that staying in open session would be detrimental to our litigation, to our bargaining rights.
and that's your motion, Rick?
Yes.
I would like to move that we move into executive.
You just take.
Say so moved.
Yeah,
Okay,
Amy's motion.
okay.
I'll second
Amy's
that.
motion.
Second. Any discussion? Now we do roll call vote. Rick? Rich?
Aye?
Aye.
Aye. So 4
And
ayes.
then we're not being
Yeah, we
recorded.
can't be recorded on this.
And David Cameron and Rich McGraw.
How you doing?
Hi, nice to meet you. Tony
Oh, it's sad. You're leaving? You're leaving,
I'm
Nancy?
not going anywhere, but she's gonna be doing zoning.
All right. Do we want to take a break, Andy, or did you want to take a break? No, I all right, oh, okay.
We already did the minutes, right?
Yep.
Okay, next on the agenda, 7 o'clock PM, is the petition of Michelle Kearney, 662 Adams Street. I'll read the notice. Town of Abington Zoning Board of Appeals will hold a public hearing on Thursday, August 5th, 2021, at Abington Town Hall, 500 Glenwitz Way, at 7 o'clock PM, on the petition of Michelle Kearney, 652 Adams Street, Abington, to appeal a determination of a denial of zoning enforcement pursuant to Section 175-80 for property at 662 Adams Street. The property is located on Assessor's Map 65, Lot 81, in the industrial zone. Andrew Burbine, Chairman, Zoning Board of Appeals. Is the petitioner here? Hi, Michelle, how are you?
Good, how are you?
Fine, thanks.
Can you hear me?
Yes, please.
I have proof of the ad. I don't know how you want that. Proof of the ad posting?
Do you need that, Nancy? Proof of the ad posting?
Pardon?
Do you need proof of the ad posting?
If you have it.
Okay.
You bring it up here.
You look so much different than you were on Zoom.
I hate Zoom.
I know, me too.
Okay.
So I'm Michelle Kearney. I live at 652 Adams Street. As you know, I'm here to appeal a decision of the Board of Selectmen to not enforce the dimensional and density regulations of Section 175-29 on 662 Adams Street. This complaint that I submitted on May 24th was my family's third attempt for the town to enforce its bylaws on the property. And as I stated in my appeal application, the first two went unanswered. So this is the first one we have to appeal to you. First, I have a couple questions. I would like to know why the property owner was never told to seek zoning relief, or how the site plan application was approved without the property owner having secured at least a variance for the property's dimensional deficiencies. Section 175-77-2C, the site plan application must meet land space requirements, among other things, which this property doesn't. Currently, there's several different uses being maintained on the property. There's open lot storage of registered trucks and trailers, goods and materials used in connection with commercial and industrial uses. There's maintenance being performed on vehicles. The house is being rented out. There's just a lot going on. And none of the conditions imposed by the planning board when they did approve the site plan are being followed. So, but like I stated in my complaint, there's been a change of use to the property. It's the pre-existing non-conforming residential use is being abandoned and changed to an industrial use. The former building commissioner said that in an email. I have copies of that if you would like it. Section 175-16 of the town's bylaws, and that has similar language to Chapter 48, Section 6, has allowed the residential use to continue without being required to conform to current zoning. But it also says that any change of use the bylaw shall apply. And whether you consider the structures, the building, the lot pre-existing, there's still been a change of use to all of it. So I think the bylaw should have been applied, specifically, obviously, the dimensional and density requirements. I would also like to know why the property owner has been automatically afforded the exemptions without a 48 Section 6 finding from this board. The only use applied for during the site plan review, open lot storage of registered trucks and trailers used for temporary storage. That's an allowed use under 175-21H3 for industrial properties. But in 175-19, it says even uses permitted as of right must meet the requirements set forth in other bylaws. Again, the dimensional requirements. And then lastly, the new allowed use since it doesn't satisfy at least the dimensional requirements, although allowed, I think that makes it non-conforming, so that 175-72A, non-conforming use to another non-conforming use, should have been applied during the site plan review process.
So you got the letter from our town council, I would imagine, right?
Yep.
The one dated June 10th, 2021. First, detached dwelling on a separate lot occupied by not more than one family. And Amy said, it is my understanding that this is a pre-existing non-conforming use. Is that correct? Or?
So, so with regard, again, Amy Questle, Town Council, with regard to the dimensional requirements, the lot is pre-existing non-conforming. So the dimensional requirements, they don't have to meet the dimensional requirements for a conforming use. And they are converting from a non-conforming use to a conforming use. And so just because they're going back to a conforming use doesn't mean that the lot somehow has to have the correct dimensional requirements. It's a pre-existing non-conforming lot. So the lot, in my opinion, is fine. The issue, in my opinion, and I'm not sure what exactly your application, I guess her application covers everything. So, so with regard to, at first I thought the application only was in reference to the dimensional issues with the lot, and in my opinion, that's not an issue. What is an issue is the use of the property. So we were informed that they were going to stop the non-conforming use, which was residential, and they were going to use a use which is 175-21H3, which is open lot storage of registered trucks and trailers used for temporary storage. This was determined by the former building commissioner as an allowed use because the trucks and equipment were not going to be there all year because they do state plowing contracts, and so they leave for the entire winter.
So they leave to go where?
To jobs, I think.
But do they come back?
They come back?
I don't think they do.
The last year, this winter, they came morning, noon, night, 7 days a week. They were coming and going constantly.
Excuse me,
Oh,
one at a time, okay? We're gonna let her have her say, and then you get your chance.
Yeah. So the use was determined by the former building commissioner as allowed. If Ms. Kearney is contesting the use, then that appeal would be, to you guys. But right now, the building commissioner, the former building commissioner did say that it was an allowed use. So, if they were going to switch to that allowed use, they therefore have to stop using the house as a residence. They cannot have two primary uses on one lot. And so, that is, in my opinion, an issue that the town should seek enforcement. They can't have two
You
principal
can't have
uses.
two principal
And-
uses.
Right, and the fact that the site plan approval was appealed by an abutter, while I think that creates somewhat of a wrinkle, it doesn't give them the authority to have two principal uses on a lot during the appeal.
So is there an open appeal of the
Site plan approval
site
from
plan.
the planning, from the
and that's
planning
coming to
board.
us?
No, that went to land court. The Kearneys appealed that,
Okay.
that the grant of site plan approval was appealed to the land court.
Okay.
So what you're seeking tonight is for us to enforce
Yes, the dimensional requirement.
dimension and the use?
Well, I mean, I thought there was going to be a cease and desist about the tenants, but
Well, your initial complaint included the use request, right? That was one of the things you had in your initial complaint, was the fact that they were using the property.
If it didn't, it's not allowed. So the building
That's true.
department can
That's true.
issue
Right.
a cease and desist.
Yep, yep, yep.
on
Have
this.
they?
Yep.
Yes, we have. We've issued 2 or 3.
And have they
No,
have not
Complied?
complied?
as far as I know. I'm not sure if anyone actually moved out of the house. Did they?
they're still there.
Yeah, no.
So it's being used.
Both.
And it's at 175-21H5, the goods and materials that were supposed to be removed, those are all still there. There's maintenance being done to vehicles. That's another use. I mean, there's several uses going on.
Did the site plan approval appeal, will that address issues like that where there's operational issues that she's concerned about? Or is it only about,
No, that would be more enforcement because it's my recollection that the site plan decision didn't allow maintenance
Correct. Or equipment,
or equipment.
just up to 12 trucks, I believe,
I think so, yeah.
and nothing else.
And it was not appealed by the applicant, it was appealed by the abutter.
right?
Okay.
Can I actually ask one more question? Then what is the difference between an allowed use and a conforming use? Because shouldn't an allowed use without zoning relief or a special permit technically conform?
So there's a difference, if I may.
Yes.
Sorry.
I was gonna-
So there's a difference between use and dimensional. So you can have a non-conforming use and you can have a non-conforming structure or a non-conforming lot.
Mm-hmm.
Their dimensional non-conformity is legally pre-existing non-conforming.
So even though 175-16 says a recorded lot that's pre-existing, if there's a change of use, then the bylaw shall apply.
But it's a change, they're going to a conforming use, which gives them some latitude with that. So,
The bylaw is not clear about that part.
yeah, so the bylaws.
So, but shouldn't there at least be a 40A Section 6 finding from this board then to be allowed to continue with the grandfathering protection or exemptions?
It doesn't specifically require a finding, though.
But they're just automatically given.
They were automatically given,
I'm sorry?
you said they were automatically given,
The exemptions, yeah.
Oh, no, so it's, 16 is written, so it says that, This bylaw shall not apply to existing building structures or recorded lots, nor to the existing use of any building, structure, or land, to the extent which it is used at the adoption of this bylaw. It shall apply to any change of use thereafter, and to any alteration of a building or structure. So that means that if they're changing the use from one non-conforming use to another, or if they're changing the use, but it doesn't combine the two, it keeps them separate.
But no matter where you look at it, if you want to say the building, the structure, the recorded lot, or the use of any of those is pre-existing non-conforming, it was exempt, no matter which way you look at it, it's still being changed. So then the bylaw should apply.
And it says to any alteration of a building or structure provided for its use for a purpose or in a manner substantially different from the use to which it was put before alteration, or for its use for the same purpose to a substantially greater extent. So that this whole thing is referencing non-conforming uses. They're going from a non-conforming use to a conforming use.
Yeah.
And so their lot is still protected. The lot is protected as pre-existing non-conforming.
Okay.
So it's more an issue of the uses versus the,
So an allowed use does not have to conform.
If the property is pre-existing non-conforming.
So, for example, so are we, we're a residence and industrial. We could turn our property into a hotel because it's allowed in industrial.
It would be a small hotel, I think.
Or actually a golf course, we could just move the hole every time. I mean, if, by that logic, we could technically do anything with the Y, even though our property doesn't meet the dimensional requirements.
You would, if you were to put an industrial building on your property, it would have to conform to all of the setbacks.
But an industrial use does not.
The industrial use is allowed.
it's a use versus the structure itself,
Yeah.
right? So if you were building something, that's different, because then setbacks would come into play, but if it's just the use itself,
Yeah.
the setbacks aren't gonna come
So
into
the
play.
difference here is that he's not necessarily constructing anything on that lot. If he were,
You would think.
he has to abide by all the setbacks.
Okay, and then, so what about buffering then?
We
Because
put that in.
you did, but technically there should be a buffer strip on all adjoining lot lines, but because there's a house in the middle of the front portion of the yard, we can't have it on the third adjoining lot line, where the initial driveway was, not the second driveway, the initial one for the residents of the house.
But that's a pre-existing non-conforming structure. And that can stay, but it can't be used as residential if they're gonna use the lot as industrial.
So you can really just pick and choose which parts you want to keep and which ones have to conform?
I don't think that's what.
Well, one way or the other,
Yeah, it's
one way or the other.
Yeah,
Okay.
you can't have them both.
And I see where
And
you
if there's
live,
no
you're right there,
Yeah,
Yeah,
I
I see.
mean, yeah, there's,
yeah.
used to be all trees and now it's,
Yeah, I know.
it's, so, I think that's it, unless you have any questions.
I don't have any questions. Do you- Anybody on the board have any questions at this point? One at a time, but let me see if the board has any questions first.
I don't have any questions.
I don't either.
Okay, thank you.
Thank you.
Anybody else want to speak on this petition? I'm gonna recognize the opponent first, and then,
Thank you, Mr. Chairman. Thank you, Mr. Chairman and members of the board. My name is Ronald Whitney. I appear here today on behalf of my clients, who are Robert and Jane Sullivan. They bought the property at 662 Adams Street about a year and a half ago with the intention of using it in his business, which is heavy equipment for snow removal. And so what happens in his business typically is, come November 1st, the trucks go out to sites like you see in Parkton and malls and various sites where heavy equipment might be needed to remove snow from parking lots and whatnot. So Mr. Sullivan was looking for a place where in the off-season, that is from roughly April until November, he'd have a place to park his equipment and to keep materials. So this case has a long, tortured history, and it appears that history will continue into the future because it has been appealed now by the Kearneys, who live right next to Mr. Sullivan's house at 662, Mr. Sullivan's property, I should say. There is a house there, and it is currently being used. That was an accurate statement you heard just a moment ago. And the reason it's being used is because we were so delayed in the process of getting the site plan approved that the property wasn't being used for the purpose intended by Mr. Sullivan as truck storage and so forth, nor was it being used as a house. Somebody who works for him became homeless, if you will. He was losing his apartment. Well, Mr. Sullivan said, well, I can't use it from what I want to use it for, so you might as well move in and use it and rent it, and at least I'll get a little bit of income out of it. So that's the reason why there is somebody in there renting the house. As I say, it has a tortured history, this process. We were before the planning board, I think no fewer than 6 times, and we changed and modified the plan on many, many occasions based on what the planning board was telling us and based on what Mr. and Mrs. Kearney were expressing to the planning board. Now, it's unfortunate that Mr. and Mrs. Kearney find themselves next door to Mr. Sullivan's property. His property is industrial zoned, and so is Mr. and Mrs. Kearney's. So when we talk about uses, the 175, I believe it's 21H, but don't quote me on that. It is 175-21. Anyways, within that section, this property in the industrial zone, an allowed use is the open lot storage of trucks and equipment. And so what Mr. Sullivan proposes to do is allowed in that zone. Now, what I understand Mr. and Mrs. Kearney's principal complaints to be here tonight is that your board should make a decision that the dimensional requirements of your zoning bylaw should apply to this pre-existing lot. I would suggest that that's not an appropriate decision, and I would suggest that based on the body of law that we call zoning in Massachusetts, which dates back to 1950s, 1960s. Abington, I believe, adopted the bylaw back in 1960. And what the intent and purpose of that body of law is, that I would suggest to the board that the intent and purpose of that body of law is to set aside different districts for different uses. If it's an industrial district, you can use it for these things. If it's a residential district, you can use it for these things. Understanding that when that zoning bylaw went into effect, there were certain properties that were being used in certain ways, and those didn't comply to the districts, and we called those grandfathered on non-conforming uses and properties. And so when zoning went in, they had to make exceptions for those non-conforming uses, and so they did. We've heard many times the term grandfathered, many times the term non-conforming. But what happens over the period of years while the courts are interpreting these laws since the adoption of zoning here in Massachusetts is that we have certain doctrines, if you will, certain intentions of going forward, and a couple of those intentions are abandonment, as is found in your bylaw, and the doctrine of merger. And what those two doctrines are focused towards is taking those non-conforming uses and over time trying to clean things up to make them conforming. So we say that if we have a lot that's undersized here, according to current zoning, and it comes into common ownership with the lot next door that's undersized, those two lots merge and become one lot. So we have a more conforming lot. We also say that if I'm running a small convenience store up on Hancock Street in the middle of a residential zone, that I should, if I abandon that use, not be able to go back and use it. So the thrust of zoning is to try to make things more conforming, not less conforming. In our circumstance, that's exactly what Mr. Sullivan is trying to do. He's trying to take what's a non-conforming use and make it conforming to that district. Now, if you accept the Kearney's rationale, that will never happen again in Abington, because any lot that is undersized in the district in which it is, if it's being used for a non-conforming use, could never be used for a conforming use. In other words, they're trying to suggest that Mr. Sullivan's lot doesn't have adequate frontage as is required in the industrial zone. We admit that. It's a prior recorded lot that existed prior to zoning, so it's given that protection as a non-conforming lot. Now, for years, it's been the site of a non-conforming use. So do we say now, do we interpret the laws to suggest that it could never become a conforming use? Because that's what the Kearneys would want you to accept and to rule on, is that this lot, and further the Kearneys lot, could never be used for a conforming use because it doesn't have the frontage required in an industrial zone. I would respectfully suggest to the board that that would be the wrong interpretation of the zoning bylaw in the town of Abington, and also an awkward expression of what the general intent of 48 and zoning is. So I would suggest that I would ask on behalf of the Sullivans that you don't accept what the Kearneys are trying to suggest ought to be the case here. In fact, the case is before the land court because the Kearneys have chosen to go there. The reality, however, is, as town council mentioned a few moments ago, a site plan cannot be denied. And the planning board expressed this when we were before them. It can't be denied. Reasonable conditions can be imposed. And I don't know if the board has a copy of the site plan that was decided upon by the planning board, but there are numerous conditions. In fact, Mr. Sullivan was given very heightened scrutiny, if you will, of his plan, and I would suggest a greater restrictions and conditions as a result of the concerns of the Kearneys. And also, I have to be candid. The difficulty in this case was not something that was thrust upon Mr. Sullivan completely. In fact, some of it was self-induced. He went forward, he didn't have a fill permit, and he removed fill from the site, and he brought new fill in. In fact, when he was doing that, he was doing it in connection with Mr. Kearney, because he was doing the same thing on his property. In fact, Mr. Sullivan was assisting him. They were working together as neighbors to try to allow for them to have their property and the use and enjoyment of their property, and at the same time, Mr. Sullivan to have the use and enjoyment of his property as he wished to use it. So I would suggest that, again, that the Kearney's interpretation of 175-16 is incorrect. And the reason I say that is because if you look at 175-16, the heading of 175-16, what it says in the title, it says existing structures and uses, semicolon, applicability to alteration and reconstruction. when you read that section, it's very apparent that what that section had in mind is that if you had a non-conforming use that you were going to extend, that you were going to alter or reconstruct, then this section would apply, this 175-16. But it doesn't apply in this circumstance. Mr. Sullivan is not looking to reconstruct anything. He's not looking to reconstruct any buildings. So when you heard the language read by Ms. Kearney, what she didn't read was the end of that sentence. And the sentence says, fully, the sentence says, it shall not apply, this bylaw shall not apply to any change of use thereof and any alteration of a building or structure when the same would amount to a reconstruction, extension, or structural change into any alteration of a building or structure to provide for its use for a purpose or in a manner substantially different from the use at the adoption of zoning. I would say that what this section really drives at is if I have a house, like the house that's on Mr. Sullivan's lot now, it's a residential home in an industrial district. If I have that, then the bylaw and this board should have a piece of the action if I'm looking to extend that. Let's say I'm looking to make it a two-family, or I want to extend it out another 50 feet and create a larger home. What I'm doing is I'm creating a greater nonconformity. And that's what this bylaw drives at, is if you're going to create a greater nonconformity, this board should have its say in whether or not that ought to be allowed. Because again, the thrust of our bylaw, the thrust of Massachusetts law has always been, let's reduce these nonconformities. Yeah, we got one here, it was existing. We got this one over here, it was existing at the adoption of the zoning in Massachusetts. But as time passes, let's try to mitigate and reduce and eliminate those nonconformings. And so I would suggest to the board, that's exactly what Mr. Sullivan is doing. He's reducing, he's eliminating a non-conforming use in an industrial district. Thank you.
Anybody have any questions of Attorney Whitney?
I was just gonna say, so you were saying that there's, as of right now, they are using the house still,
Yeah.
and they are not storing anything on the property, no trucks, no, you said that they,
No, I can't say that because I spoke to Mr. Sullivan about that subject last week, and he tells me that there are still some trucks
Couple
there.
of trucks were moved on after we had the planning board approval to do that work.
Okay.
And I've subsequently found out it's being
Mr. Sullivan,
appealed.
can you go up to the microphone just so we can catch this on? Thank you.
A couple of trucks were moved on in anticipation of doing the work that was required according to the planning board, but then it was appealed, so they've just been sitting there waiting. I have two trucks on there for security purposes. One's owned by me personally, the other one's owned by the business. And one's parked in front of the garage, the other one's parked in front of a storage container, so nobody breaks in.
Any other questions?
What was this property before you bought it?
It was a residence, single family.
Now it's both.
Automatically, it's both?
No, they're using it as both.
Right, so,
So, I mean,
Yeah.
the issue that we have is that there's two principal uses on that property, and that can't happen. He does not have site plan review, because site plan review was appealed, so it's not final. And so therefore, he cannot use it as temporary storage for trucks, et cetera. He can't change the use without site plan approval under 77. So, I mean, I would suggest getting locks for the garage and locks for the storage container. I mean, I don't think you have to park trucks in front of these, I mean.
But can he use it for residential
He can keep it
rental?
as residential.
In-
Once he changes it, he needs a site plan, and he hasn't gotten site plan.
so in residential, you can't park what I see here is trailers and,
Well,
Trucks.
yeah, he would be using, exactly, he would be using it as two uses, two
what she's
primary
doing
uses.
right now.
Which he can't do.
Right. So it's residential before he bought it.
Does that not happen throughout the town?
Well, if you have residential, you can't stop parking. If I bought a house in Abington, I wouldn't start, and I started parking, say, trailers in the back of
I
my,
appreciate that, I understand that.
I mean, that's what we're looking at, right?
Yeah.
Okay.
Any other questions for Mr. Sullivan or Attorney Whitney? If not, anybody else who has to, want to have a say? Yes, sir? Thank you. Thank you. Name and address, please, sir.
Yep, Pat Kearney, 652 Adams Street. So just, as you know, just by mentioning that he has a truck parked in front of the storage container, that there are more things than just trucks on the lot. My question was, and we also know that, as Mr. Whitney said, he decided to rent out the house because he said he couldn't use the property, but the industrial use had never stopped. It's been going on all along. And that was after Ms. Questle herself issued a cease and desist to ordering him not to occupy the house. So my only question other than that is, along the property line between the two, along the driveway, the existing driveway on his side, it's the bedroom end of my house on my side. I believe Ms. Questle would agree with me that we did determine that 20-foot buffers were required when industrial borders a existing residential. So that being said, they reduced the buffer to 10 feet along the driveway so that he could have a driveway on that side. Would the reduced buffer strip require a variance from the board? And we're not trying to set a precedent that you could never open an industrial property. We just believe that you need a variance if you don't have the dimensions. He's not 2 or 3 feet short. He's 17 feet short on the frontage and the lot width, which is why they had to reduce the buffer strip along the driveway, which goes along the side of my house where my bedrooms are.
And the reduced buffer was part of the site plan, Amy, is that?
Yes, it was, because I think that, if I may, I
Yep.
think that that's something that the planning board's allowed to waive, which is why it was brought to 10. I think it was 10, correct?
Yeah, 10 feet
foot
with
wide, and
with trees.
landscaped. Yeah. Yeah, so that's why. It's not in the dimensional chart. It's in the site plan review section of the zoning bylaws, so it's not necessarily a firm setback. It's
Okay,
a
well-
setback only if you have certain things, so that under the site plan reviews, the planning board can waive certain things.
Would they have to put that to a vote, though?
It would be their, part of their decision.
And there was never a vote on
But
that.
if
There was never a motion.
They approve the plan. And
Okay.
It shows on the plan.
Okay.
Yeah.
Okay. Thank you.
Thank you.
So this has been approved by the planning board?
Site plan is.
Site plan was approved by the planning board, yes. With conditions that they could only have, I thought it was 10 trucks, but it's 12.
It could be 10,
I don't.
Do you know, Attorney Whitney, do you know if it's?
Actually 12, and
12.
substantially less than what I own.
So,
17 vehicles that are on.
so there's 12, so they limited the amount of trucks. They said no equipment, it could only be for trucks. They are requiring stormwater, they're requiring landscaping, screening. But the problem that we have is that we have that existing house. And so that existing house cannot be used as a residence.
But it can be at this point because this is being appealed.
But then he can't use, he
They
can't
can't
store
use it for
trucks. He
storage.
can't have both.
Right, you're right, I understand that, yeah.
You just can't.
I
Right.
just wanted to make note to the board that I've spoken to Mr. Sullivan last week. He has begun the process of removing the equipment and any vehicles, and he tells me tonight that he is going to continue that over the next week to a point where all the equipment and the vehicles will be removed from the site.
Thank you.
So unfortunately, I think that that's really great to hear. However, I received a letter from Attorney Whitney November 27th telling me that the house was unoccupied. On December 28th, I then received a letter from Attorney Whitney saying, oops, I was wrong, the house is occupied. So I have the letters. So, you know,
If I may, Mr. Chairman.
Go ahead.
When I wrote the letter, the first letter, I think, did you say?
November
Journey
27th.
Questle, November 27th. The house was unoccupied. As I mentioned in my opening comments, Mr. Sullivan had an employee that that needed a place to live, and he moved in. And decision at that time, he consulted with me, and I said, you know, you don't have approval to park trucks out there or put equipment out there. But the house has been used from time immemorial as a house, and nobody has said you can't use it as a house. So if you got somebody that needs a house and you want to rent it with the understanding that you can't use it because you couldn't use it anyways without the site plan approval, you couldn't use it for the purpose intended. So, you know, I spoke to him, and then when it became apparent that he was going to go forward with the plan to put his employee in the house, I immediately sat down and wrote a letter to council so that she would know that Mr. Sullivan's plans with respect to the house, at least while we were trying to get through the site plan approval, had changed.
So going forward, Mr. Sullivan understands that there's only one use allowed.
There's one use, and the only one use that's allowed is as a residence right
Right.
now.
So
Because
storage of trucks, trailers, all that stuff has to stop.
It has to stop, as council says, until, because of the appeal of the site plan now, we don't have approval to do that activity. So
Would they be
that's where
coming
we are.
before us with this, or is this just a planning board thing?
no planning board, because it's an
That's
allowed
it?
use.
So I guess my big question is, H3, open lot storage of registered trucks and trailers used for temporary storage. Do we know what temporary storage actually means? And did the building inspector say that it was being used for in his decision, did he say it was being used for temporary storage? He did. And that's based on his investigation of,
Yes.
And were there hours put down of what they can, I mean, I'm looking at this right now, and if this is, I mean, there's trailers everywhere and vehicles parked everywhere.
You're looking at the right property?
Oh, yeah, right there. That's your property.
I guess my question is temporary storage non-snow season? You know, non-snow season is
Well, like last year, we
potentially.
had no snow.
Yeah, that's true. But you still have to, I understand you still have to get your trucks out in there just in case the snow comes, but is that something that can be relooked at, or?
Oh, yeah, we should. I mean, I mean, this use, I don't think so, because I think the determination was made and it wasn't appealed.
But I think that's part of this appeal, isn't it?
No, this appeal is based on this appeal is the dimensional, requirement and the use of the property with two uses, I think. I thought it was just the dimensional.
Change of use, but at least in the letter, grounds for appeal to us.
Okay.
Change of use of the town zoning bylaws states, any non-conforming use or structure may change to another. The new use of the property, open lot storage of registered trucks and trailers, use of temporary storage is substantially different from the prior non-conforming use of residence. It says, the use of property has caused readily observable differences. Yeah, I don't know. I guess that's where I get hung up, is whether or not the building inspector did his due diligence in determining whether or not this was a temporary use versus a
Can I take a look at this?
permit.
Yeah.
And if that can be looked at again, that's,
I don't know, actually, because, there's no building permits issued. And I don't think that the building commissioner ever issued a determination in writing as to the use. So, I think that, Ms. Kearney can ask the building department under 48, section 7, for a zoning determination that is the use
Allowed.
that's going on. temporary or not, and then she could, potentially, if she doesn't like the answer, she could appeal
Come back
that
to us.
to you guys.
Do you have a time frame for the appeal process for the site plan?
I would say a year or more. We're in land court, but, there's 6 months of discovery and then motion. So discovery is gonna close on, January 21st of 2022, and then, that was the last date that the judge, issued, and then there would be motion practice. So yeah, it would be at least a year.
And once that process is done, you don't have anything more to do with it, right?
Unless the use is, challenged. And, if they continue at the case management conference with Judge Foster, if they continue with 2 uses on one property, then I would go in, I would seek an injunction, or the Kearneys can seek an injunction, and we would, the judge had explained that we would, it would be combined with the current case. It would be a related case.
No, I get a better idea by looking at that. It is amazing that residential area could be made into that.
Well, it's zoned industrial.
Industrial zone.
Yeah. Right now, residential,
Mhm,
being used for.
mhm.
If they tore the house down tomorrow,
It's fine.
But they still wouldn't have the
They still
plan
don't
approval.
have the planning board approval.
would it be considered industrial more? I mean,
It's industrial. It's zoned industrial.
it'd be used for storage or whatever.
Mhm.
If the house wasn't being used or wasn't there, we wouldn't have this problem, right?
Right, because because the use was residential and the use changed to industrial, they had to get site plan approval.
But the use still has to be in conformance with the zoning
Yeah,
bylaw.
right, it's a
Still,
strange
if
one.
it's not in conformance, even
I
if
mean,
it's
you
an
look at that,
industrial
you don't
zone,
think
it's
it
still-
would be,
So what do you suggest going forward?
So I suggest that, the zoning board, deny the appeal with regard to, the challenge of the dimensional size, the dimensional aspects of the lot, and, instruct the building department to, determine if a cease and desist has to be issued with regard to 2 uses on one lot.
And then going forward, if there's a question of the use, then the Kearneys have the right to go to the building department and ask them to make a determination.
I don't recall Marshall making a written determination on the use. I don't know if you guys got one. Yeah.
But that's only once that use is in place too, right? Or would you do that prior to, or?
It is in,
Get the-
I mean, technically it's in place because, I mean, it was in place it was being used both,
Okay.
without site plan.
right.
So they would have that right to do that now?
I think they're only protected from, an appeal if their use is allowed, meaning it's the only use on the property and they have site plan approval.
Okay.
And that hasn't happened yet.
Okay. Anybody have any more questions?
How
Should
do
we,
how do we address the building department in terms of making sure that it's only one use at a time?
The building department will have to do numerous inspections just to keep up.
But can we direct them to do that or just request it?
But request it, yeah, you guys can request that, to do that, and then, I'll talk with Scott, about what he wants me to do. The Board of Selectmen also have enforcement powers under the zoning bylaw.
so to speak?
Actually, you don't have a building commissioner.
I thought we did.
Oh, you haven't, do you have one? No.
Scott is right.
Yeah,
Scott's
yeah,
the
Scott is your
Yeah,
building commissioner,
right.
yeah, so. I'll talk with Scott about it.
So should we entertain a motion to close the hearing, I guess, at this point?
Yeah, I don't think there's anything else.
May I ask one question?
Yes?
Just to be clear, Pat Kearney, 652 Adams. So the only use right now that can take place on the property until the site plan is, the site plan appeal is finalized, is the residential use?
Yes.
That's my opinion.
Okay, thank you.
So can I have a motion to close the hearing?
Make a motion to close the hearing.
Is there a second?
Second.
All those in favor?
Aye.
The hearing is closed. Okay, so now we need to deliberate, or any motions, or?
So I think that you can make a motion to deny the appeal, based on the fact that the property is, pre-existing legally non-conforming. And then that would be your motion. And then after you make your motion, you can ask town council to, be in touch with the building commissioner.
So why don't we do two motions? That
Sure.
first motion, and then, so does somebody want to make a motion to
I'll make a motion, so.
deny the appeal?
Deny the appeal based on the fact that the lot is pre-existing non-conforming.
Make a motion as
Motion,
it
Dave?
was stated.
Is there a second? And a second. Any discussion? If not, all those in favor?
Aye.
Opposed? That's unanimous.
And then make a motion to have town council coordinate with the building commissioner regarding future enforcement, if any.
Okay.
I'll make that motion.
Rick's motion.
I'll second
Dave
the motion.
seconds. All those in favor?
Aye.
Opposed? That's unanimous. Okay. Thank you. Thank you.
Thank you all.
Thank you. Okay, next on the agenda, petition of William Creighton on 0 and 22 Helm Street. Read the notice. The Town of Abington Zoning Board of Appeals will hold a public hearing on Thursday, August 5th, 2021, at Abington Town Hall, 500 Glenwood's Way, at 7:10 PM on the petition of William Creighton, 53 Vineyard Road, Abington, to appeal a determination of a denial of zoning enforcement pursuant to Section 175-80 for property at 0 and 22 Helm Street. The property is located on Assessors Map 64, Lot 61 through 65 in the Business Development District. R. Andrew Burbine, Chairman, Zoning Board of Appeals. Mr. Creighton here? Oh, you, Bill?
William Creighton, 53 Vineyard Road in Abington, Mass. Would like to start?
Yes.
Okay. So as you can see, we've been before the Board of Selectmen. We're satisfied with their decision. I think it's inadequate. What's occurring on this property. There's actually 3 lots here. It's all been kind of combined, stating one lot, but it's not. There's 3 separate lots here. On Helm Street. So there's, you can see this says 0 Helm Street and 22 Helm Street. 0 Helm Street is actually 2 separate lots that are across the street from each other. They're across the street in Helm Street. Lot 65, which is the lot that abuts and joins the auto body shop that's there. That was purchased in 2008, well after the technology business zone was introduced or enacted. As we know, the technology business zone was changed to business development. So those business development zoning laws apply to all 3 of these properties right now, including residential. If you look at the lot 65, the Warner property, like I said, it was purchased in 2008 after the technology business was enacted. you look at the zoning map, there is a tiny piece, granted it's a very small piece, but there's a very small piece of this property in the zoning, residential zoning district. Granted it's small, but it's there. Well, part of the process, this whole thing is, we were told by the building department that everything there is grandfathered. We asked, what is grandfathered? What use is grandfathered? We've never received a document stating what the use is, what the grandfathering was on any of these properties. So how can you have grandfathering if you don't state the use or the company? Even today, on these 3 properties, there is no business permitted there in the town clerk's office. In the town clerk's office twice, in the buildings commissioner twice, and asked, was there any permits on Helm Street? The answer was no. The auto body shop and the automobile sales, they're listed on Bedford Street addresses, so that's why they're not part of that statement. So 65, like I said, the business development zoning laws apply, because it was forested too. There was trees there, and after it was purchased in 2008, trees were cut down. So there was nothing going on there previously, 2008, nothing. There was no businesses on that property. The other lot on 0 Helm Street is lot 64, which abuts lot 63. And if you look at the zoning map, well, that was just purchased in 2019, just a couple years ago. If you look at the zoning map with the lot lines on the zoning map, a large portion of this property is in residential. The remaining portion is in the business development. But there's a large portion in the residential, a substantial portion, well, at least 50%. And that was not stated in town council's letter. And in 2019, after the property was purchased, all the trees were cut down. It was completely forested. You go there now, and there's boats there, salvage boats. It's not boat storage. This is the height of boating season. All the boats are still there. These are all boats that are junk. They're brought in, parts are sold off of it. And what they do with it after that, I don't know. And salvage yards, vehicle salvage yards are not allowed in the town. A boat is a vehicle. It's got a motor to transport you someplace. So that is lot 64. Again, it was fully treed. There's no permits for anything that's occurring on there right now. Then there's lot 63, where there's much activity on there now. Again, there's no documents in the town hall that I've received from the town clerk's office twice, or the building department twice, asking what businesses or what uses are going on in these properties. All I received from Mr. Adams, Marshall Adams, was grandfathered, the one word grandfathered. He asked, well, what use is grandfathered? Never could get an answer. Well, what companies were operating in these properties? Never could get an answer. So how can you state grandfathered, and we don't know what the grandfathering use is, and there's no companies there, there's no businesses there, and no records of any business there in this town hall? And interesting enough, earlier tonight, you were just talking about a property can only have one principal use. This property has a house with a registered voter in it. So you got a house with a registered voter in it, and all these businesses, all in the same lot. There's 3 lots there combined with the one lot 63. So you just took a stand earlier tonight saying you can't have 2 principal businesses, 2 principal things on the same lot. Why are we having it here? Why is there a house with a registered voter and all this business activity, which is unpermitted according to the town clerk's office? What else we have? Any questions?
Any questions? I did have one, Bill. Back in July of last year, it looks like Marion Wong Ryan sent you a letter
Mhm.
with her decision to not enforce, and she mentions grandfathering, but you didn't appeal at that point.
We didn't ask for a zoning determination. What we asked for them to enforce the zoning laws. We asked them, could you please enforce the zoning laws? That's all we asked for. We did not ask for a zoning determination. We said enforce the zoning laws, do your job.
And they declined, so under 40A.
They declined to do their job.
Right, so, but, so under 48, as Amy was, go ahead and finish. Amy.
So under 40A, if they can decline to seek enforcement, and therefore, maybe you have 30 days to appeal that to the zoning board of appeals.
So you were sent a notice saying that they weren't going to enforce, and at that point in time, you had that 30-day clock started to tick, and the 30 days would have expired in August of last year.
But we never asked for that. We were on vacation at the time. There was just no time to do anything. There was no request for a zoning determination.
There's a request for zoning
For enforcement.
enforcement,
Right.
which is,
Zoning enforcement.
which is the same thing in section 7. In fact, I think it says enforcement. That 30 days is firm. There's no way around it.
Could they have done it again? Could they have sent another letter to,
Only if something changed, significantly changed.
So that was my next question.
yeah, sorry.
No, go ahead, Rich, go ahead.
No, I was just wondering if they, set one tomorrow.
Right.
I mean,
No, they can't, no, that's repetitive petition.
How about for a new uses there?
Well, that was going to be my question to you. And
Sure.
I guess in your submissions here, you say that within the last 6 months, all these boats have been coming in.
Correct. All the
That was-
boats that are coming in.
That was after this determination by Marion back in July of last year. So if there's a new violation, or alleged, Amy, so if there's a new alleged violation like that, where all of a sudden there's a big storage of boats, parks.
So, correct, so the building department would have to determine either, yes, there is a difference and we're going to enforce, or no, there's no difference.
But Mr. Creighton would have the right to,
He would have the right to appeal to you that, yes, there is a difference.
but he'd have the right to go to the building department now and ask them to make that determination.
In addition to that, since that came out, there's a diesel tractor trailer truck. It leaves early in the morning. It left at 2:50 a.m. this morning. Yesterday morning was 2:46. Who knows what it's going to be in a few hours from now? Because it's not a permitted business, there are no business hours for the trucking business. Every other business in town has business hours when they can operate. But here, we got a truck that can wake up myself and the neighbors. It's not permitted. It's not zoned for business development. And it's going on now. I can call you up tomorrow morning if you like. Bring you up to the truck, you can hear it start. In wintertime, it's worse because diesel trucks, you have to idle a long period of time for the engine to warm up. So we're there for a half hour, 45 minutes, early in the morning, waiting for this truck to leave, which is also a violation of state law. State law says you can only idle a motor vehicle engine for 5 minutes. That's it. So we did make complaints. We did call the police department earlier this spring about this. We did send complaints into town hall. As you can see, nothing happened.
Any other questions for Mr. Creighton?
So there's been a couple of changes in what you've seen on the property since you were denied the by Marion? Right. Yeah. Would he have to make a separate appeal to Marion again, or to us?
I think that's what, no, it would go through the building department first.
Okay.
Yeah, and if he's not satisfied with that, then he could come back.
So what if this board decides that determination is incorrect? Does that determination stand law forever? even though you may determine?
I think the point is we can't make a determination because you didn't get your appeal in within that 30-day period. But that doesn't mean that if circumstances have changed
Mhm.
since this determination, that you can't file for another one.
So the two
And if you
principal.
do, and it's denied, then obviously you want to make sure you hit that 30-day period, because otherwise that's going to not be heard either.
What about the two principal uses on one lot, the house and businesses? You just heard earlier, you cannot have two principal uses on a single lot.
But that was not, again, that's not before us tonight, so you'd have to.
It is,
No, nothing.
22 Helm Street.
That's not, that wasn't part of your appeal.
So can I make another appeal on that?
That's what I think we're saying, is that
Okay.
His appeal has to be to the building department,
that
right?
goes to the building department, yes,
Yeah.
for a determination. And if you're not happy with the determination from the building department, then you have that 30-day period to make an appeal to us,
Okay.
okay?
Can I just ask Amy a few things about this?
Yep.
Is this a grandfathered situation, or?
Yeah.
I mean, looking at this property, I mean, I got the Google map out, and it is loaded with stuff. From cars to boats to trailers to wood to, you name it.
So it's in the it's grandfathered industrial back in 1988, and then it was changed to TCC, and then that, 1990, wait, it's in my memo.
Does that give them the right to put anything and everything on the property?
No, it doesn't. It gives them the right to have an industrial use. It was changed, so then in 1998, it indicated that it was located in the industrial zone. And then in 2000, the property was rezoned from industrial to the technology business zone,
Which is,
which is now the business development zone.
right.
And so, the building department determined that the use was allowed as pre-existing non-conforming industrial use.
What use?
Well,
You named the use.
And-
Not
and-
the building department.
you're right.
The
And,
building department never stated what the grandfather use
understand.
was.
and I do see the residents too, what you're talking about.
It's a registered voter living in that house. So, once again, I'm asking the town, you've stated different departments, it's grandfathered use. Ms. Kessel has documents saying it's grandfathered use. Well, what is the use that's grandfathered?
I think Amy's only telling you what the building department has determined, which is all she can tell you at this point.
How can they inform something if they don't tell you what it is that they're?
But I think it still goes back to the fact that you waited a year to.
So it's my fault.
I'm not saying
No,
it's your
no,
fault.
it's
I'm not
just-
saying it's your fault, Bill, but you have to follow the procedure
Yeah.
in order to get it in front of us. So what I'm suggesting is follow the procedure and get it back in front of us.
Is there any oversight on the building department to do their job properly and to state what uses are?
From
We're
this,
not-
not from this board.
We're not, no,
Who
we're
does
not,
that?
This board.
Does anybody do that? Are they just free to do whatever?
I don't
Say
think that's the
grandfathered
case,
and
no.
walk off.
I think he answers, or she answers the town manager.
Uh-huh. Well, right now, the town manager is the,
building commission.
uh-huh.
And the town manager answers to the board of selectmen.
And we do have a building inspector now, right? We have an inspector now too,
Inspector,
right?
but no we have a building
That's who we met
inspector, but
today,
no
right?
commissioner,
Yeah.
so-
Yeah, he's very good.
Acting commissioner.
So, just so I understand this, because it's grandfathered from industrial to the what's that, the other
Yeah.
two steps you mentioned, do any of those steps require a site plan?
Not unless he changes the use. So if the use has been there since 1988, which is what the building department determined, and it's an industrial use, it stays.
But who defines what industrial is for that purpose? Because it sounds like things have evolved over time.
The zoning.
The zoning bylaw.
determines what's
So the
industrial.
use table would tell you whether or not
Okay.
it's, yeah.
You said if they change the use,
Mhm.
how can you determine how the use has been changed if we don't
Industrial
determine what the use is in the first place?
The building department determines the use, not me.
Correct, but they did not. They just said grandfather. They never said what the use is. So how can we say there's a change in use if the use
Does it
is
say in here
never
that you had to appeal it in this letter?
Yes, it does.
So
Any
that's
person
where
aggrieved by this determination may appeal to the zoning board of appeals within 30 days of the date of this determination.
So you have another chance here. I mean, you have noticed something different, so.
Right.
I mean,
I think that's
you
what it
have
comes,
another
I think
chance
that's
to
what it
go in
comes
front of
down to.
them and most likely go in front of us. And
Well, maybe you don't have to come back in front of us. Maybe the
Maybe
building
not,
department does, something different.
What are the odds?
I don't know.
I do.
Well,
So, I'm sorry, she determined that it was a grandfathered non-conforming use.
right.
So.
But I think Mr. Creighton's saying she didn't
Oh,
say what
she didn't say exactly.
specifically what the
Got it,
use
got it.
was.
Okay,
Yeah.
okay, okay.
Now, how can there be a change of use if we don't state what the first use is?
Okay, any other questions for Mr. Creighton at this point? Anybody else want to speak on this? Yes, Mike?
Michael Noonan, 63 Mulberry Drive, owner of the property. First of all, the letter from building department, is that the one you have dated July 23rd, 2020?
That's correct.
Okay, so you have that. And then that was appealed by the Creightons to the selectmen, and there was a letter from town council, and that stated June 10th, 2021. Do you have a copy of that? Okay. So that's been two appeals on the same, what the Creightons are trying to say is non-conforming and so forth. Little history on the lot. I bought the lot in 1996, the original lot. There was a house there, and she was renting some of this property to, at that time, Whitman Body Works to store vehicles. When I bought it, I made sure with an attorney and so forth, and the building inspector back then, her name was Mary Lou, and open lot storage was okay, as that was back in, when I bought the property, okay? Since then, I tried to put a building up, went through the process and so forth, finances disappeared, so it has been the same use since 1996. I bought the property from John Warner that had already been cleared and been filled and everything else, and that goes back in, that's still industrial zone, and I bought that in 2008. That would be the property that would be behind Whitman Body Works. Since then, I bought the property from Romano, which is behind my property. And that property, part of it is also as industrial zone. And I have this is from an old plot plan, but I can show you how it's industrial zone and where the industrial zone is if you want to see it.
Yeah, sure.
Okay, I'm sorry, I only have one of these.
That's all right.
Here was the building I was gonna put up, and, it was saying right here, this would be the technology. This would be the old Ben and Eddie's over here. And right here is technology zone, which was formerly industrial zone, which goes down the middle of the old Ben and Eddie's property, Krabby Realty property. Okay, and it comes across behind into the Joseph Romano property, which I now own. So this portion of the Joseph Romano property is industrial zoned. This is the property that I originally had, and the house is still there. The lady was in the house, and she used to rent some of this property to Whitman Body Works. And in this industrial zone, you have trucks, you have open lot storage and a couple of different properties in the industrial zone up Route 18. I'm doing nothing different than other properties are doing. And if I hadn't lost the financing, then this indoor sports facility would have gone up. But since then, I've just been using the.
On that map, where is that property? These are your properties here.
Okay, no, not this one.
Okay.
1, 2, 3, 4, and 5. No.
It says assessors, these are the assessors now.
Okay, I'm going the other
Yeah, you're
route.
coming up Helm Street this way.
1, 2, 3, 4, 5.
I see you own all.
I don't know the first
All
one.
right, these three.
These have been combined.
And where's the industrial zone on that?
This would be right about.
So it's on this one?
It would be just about here.
Okay.
Just about there is where the industrial zone stops.
Industrial's here? Or here?
No, this way.
This one.
This,
All right.
this would be all industrial, all through here.
All right.
And it showed right here, this way.
Yeah.
That's helpful.
Thank you.
Besides that, you know, the constant appeals and the constant, this has been going on with these people since 1996, and it's been a frustrating event. But every time they've tried to go in front of any board, the DEP, anybody, I have been found in compliance. And that's basically all I want to say. And there's been two appeals, you have two letters, one from the building commissioner and one from our town council that says I'm still in compliance.
Okay.
And I do have someplace,
My
the
letter says
old
the
and,
appeal's too late.
excuse me?
My letter says the appeal is too late.
Right.
Someplace, I do have the original industrial zone that says I can, oh, and I want to make something clarified. Those boats have been there for a long time. Those boats do not get salvaged in the, on the property. The boats actually belong to the deputy. He owns Continental Marine in Quincy, and he's the deputy fire chief. He would put nothing on my property. We talked about this. That would have any kind of adverse effects on the property. The fire chief has already been to the property. The fire chief has a list of all my tenants, and he has okayed what is going on there. I try to do things right, but I hate to take up the time of all the boards, but here we are.
Hold on a sec. Anybody else?
Oh, I'm sorry.
Yes, any questions for, thank you.
Thank you.
Yes, Bill.
Here's the, it's two copies of the zoning map here. So, this is Route 18, that's the street, this is Howland Street right here. There's a very tiny triangular piece. That's one piece of a larger lot, that lot is here on Howland Street. So there is a piece, it's a tiny piece,
What's the yellow represent?
residential.
Residential. What's the green represent?
This is development. Then the little square piece, that's Helm Street, but then this piece here, on the elbow down, that's the old Romano property, that's now another Zero Helm Street. Zero Helm Street's actually two lots separated by the street. You see, the majority of this lot here, you just purchased in 2019, is owned residential. Portion of it is business development. So, so there is,
You can have
there is
that.
a piece of two of the lots. So again, there's three separate lots here. And we've talked about, since it was brought up, about DEP. If you look, 2 nights ago in this very room, the conservation meeting occurred here. If you look online, the YouTube video, towards the last half hour of the meeting, the same property was discussed, and it was discussed that DEP is not satisfied with this property. There's a certificate of compliance that was requested in 2008. It's not been granted by DEP because they are not satisfied yet with what's going on there. And you can look at the conservation meeting on YouTube about that. And so I'm guessing now you know that there's two principal uses on one property. There's businesses going on and a house going on. So that, because,
But again, that's not in front of us tonight.
so but nobody in the town's gonna do anything unless I appeal it?
I think you need to notify the building department that you.
They know.
Well,
So it's,
I can't advise you.
okay, I understand, I didn't realize.
But again, if they make a determination, if you put in a complaint, they make a determination, you're not happy with it, just make sure you file your appeal within the 30 days.
I was just hoping those departments would be more forward in.
Well, we're kind of constricted by what the law tells us to do, and if it's a 30-day appeal,
I
it's a
understand this
30-day
board.
appeal.
Yep. And, I don't know, the boats are not registered. The boat's supposed to be registered with one of the departments of the state. Are they supposed to be registered? that part of the
I don't
deal?
know, if
Schedule?
they're in the water, probably, I'm not sure.
No, then
I don't know.
boats are not going in the water ever again. All right, thank you.
Thanks. Last one.
Okay, I just be clear on, I know it has nothing to do with this board, but he just made a false statement. The certificate of compliance that I tried to get was in February 11th, 2020, not 2008.
Thank you.
Look at the meeting.
Bill, that's, any other questions from the board?
Nope.
Any other comments from the audience?
On business?
What, excuse me?
Business first?
Do you want to speak on this petition?
Not on this one, on something else.
Okay.
Isn't your agenda?
Yeah,
Yeah,
we'll
done.
deal with it afterwards, but, okay, so, why don't we have a motion to close the hearing at this point?
I'll make a motion to close the hearing.
Seconded.
Any discussion? If not, all those in favor? Aye. Opposed? Amy, what do you suggest?
Motion to deny the appeal is untimely.
I think there's
I'll
really
make a
nothing
motion.
else we can do.
Yeah. I'll make the motion as stated.
Seconded.
Any discussion? If not, all those in favor?
Aye.
Opposed? It's unanimous. That's all we have, thanks, guys.
Thank you.
That's all we have on the agenda, so,
Yeah, this is one quick question.
okay.
Kevin
Famous
Keating-
last words.
Yeah, yeah. Kevin Keating, 272 Spruce Street, Abington, of course. You had an executive session tonight about a Superior Court case.
Correct.
That involves 283 Spruce Street.
Correct.
Is there some place that I can find the results of the executive session?
Once everything has been resolved, at that point, we couldn't release the minutes, but not until that's been resolved.
Any idea how long a period of time that would be?
Quite a while,
Quite a while.
but,
It's in litigation at this point in time.
Well, I know it's in the Superior Court case,
Correct.
and they're not able to give me any information on it. So all I'm looking for is, Amy did say tonight, after the executive session, it's up to the chairman of the zoning board whether he will release the results of the executive session or not. You said that tonight.
He can only release them once the action is over, and then he determines that releasing them will not be any detriment to our litigation strategy. So he can't even think about releasing them until the litigation's over.
Okay.
Hopefully it will work out well. Well, I'm hoping, anyway. Thanks for your time.
Thank you. Sorry it took all this time waiting for us.
That was appealing the Board of Selectmen's decision, not the building department's decision.
No, the Board of Selectmen held that it was untimely in their decision, because they went with my memo. The letter just said, see Amy's memo.
Yeah.
No, look at it, that was appealing their decision, not the.
Well, if their decision was that it was untimely, then we would uphold their decision it was untimely.
Well, I have to go read it. What if it says was not untimely? What if they said there are other reasons?
I'm pretty sure it said, look at Amy's memo.
All right, I don't have it around me.
It says right on the agenda, he's appealing the same thing that we are, the 17580 complaint to the Board of Selectmen and the decision not to enforce.
Right, so his appeal is denied as untimely, the Board of Selectmen held it was untimely, so the appeal is denied. They're upholding the Board of Selectmen.
Is that the Board of Selectmen's decision? I'm not sure now. I'm not sure what it is.
At the selectmen's meeting, they were both told to appeal the Board of Selectmen's decision.
Right, and he did appeal. By appealing it, this board also found it to be untimely.
Right.
Is all.
I don't think there's anything else we can do. It was untimely.
You're upholding the Board of Selectmen and denying the appeal.
Yep.
I'm just, I
The
don't know.
appeal was untimely. Bill, I don't think there's anything else we can do. The appeal was untimely.
I have to go back and read the Board of Selectmen. I don't know if they said it was untimely.
But even if they didn't, I think,
They didn't, they said we're denying it based on the memo attached here too. And it's my memo that's attached. It was in here.
Did you say it was untimely?
I did, definitely. I said right here that it's final, provided nothing significant has changed between
Yeah.
July 23rd and now. So
Right, you did.
I did.
I don't know, the Board of Selectmen, I don't know if they did.
I don't think so. It's in here somewhere. Maybe it's not, maybe I'm confusing it with the Kearney's, because theirs was in here.
Yeah, I didn't see it, I didn't see their decision.
Well, you can't have an application without the document that you're appealing. So we can deny it as the appeal not being complete, the application
Procedurally correct.
not being complete. I mean,
Hey, no, I mailed everything in. I mailed everything in to you guys.
I don't see a copy of their decision in here, Bill.
We've already voted anyway.
Right.
You can't
Can't unvote.
change it.
Well, I'm not sure what would change anyways. It was untimely. I would imagine the Board of Selectmen must have thought it was untimely as well, if they followed your recommendation, right?
That was not brought up at their meeting.
The fact that it was untimely?
That was, yes, correct, that was not brought up.
Well, we voted that it was untimely.
I agree, but I was appealing their decision.
It's not a, well,
It was based on other things.
based on what?
Other things.
Yeah, well, I don't
Amy,
think
you
we
don't-
can undo our decision at this point. so.
Nancy, you don't have a copy of it, do you? The meeting?
No, it would have had been included in
Oh,
his
okay,
submission,
all right.
but it's not in here, so.
All right, I'll do it.
We have a motion to adjourn?
Move to adjourn.
That's fine, but
As far as completing the appeal on the 17580 complaint to the selectmen, he's definitely on time for that. The letter that chose not to enforce his own bylaws. Irregardless of the determination.
But
by the
if
building
the
department.
determination of the Board of Selectmen was that it was untimely, then we're upholding the Board of Selectmen's decision, that it was untimely.
Can I ask a random question? So last July, we asked for enforcement, we never got a response. Could we have appealed the lack of response?
I don't.
You have to ask Amy that.
Yeah, did,
You want to
Because
wait?
I know in 48 section 7, even if they're not going to enforce, they have to put that in writing.
well, I agree, they should, yes. Yeah. All right.
Move
Look at
to,
the last half hour of the conservation meeting on YouTube. It's interesting.
Thank you very much.
well,
Thank you.
I move to adjourn.
Thank you.
Is there a second?
Second that.
All in favor?
Aye.
Aye.